Moving on, we have Neil who's called in. Neil, how can we help you?
Yeah, actually, good evening, both of you.
Good evening.
And I just wanted to have a query on, the particular issue. Now, see, it's like this, that there is a property which is a land which is in my mother's name, which has been given to her by her father. That means my maternal grandfather. Now, we didn't have any claim on this, or rather we were not claiming on this particular property. But now it has come to the notice that this property is being disposed of by my relatives. Now she wants to lay a claim on this. So we'd like to know what would be the legal position here and how can we claim that?
It
Neil,
is
here
in her name. Can she claim?
again documentation is very important. You are saying that your grandfather has transferred the property to mother's name.
That's right.
Right. But then one has to see whether that was an ancestral property of your grandfather or was it self-earned property of your grandfather, how it was transferred on your mother's name.
This has been an ancestral property.
So if it is an ancestral property, there would be rights of other people also. Now, how it can be given to your mother? He can't will away.
No, the properties which were given to my mother, her sister and her brother.
Correct. Now this is the half information. Now the correct information is coming. Now if there were so many claimant of the property on whose name the property was given, was it by will or was it by transfer?
It was by will.
So if it is by will, was that will registered or not registered? All these questions, what I would really suggest is you give them with a synopsis with all documents to a proper property lawyer. He can go into this document. Why I was asking you a question is to only impress upon you that this is not just a hasty runaway or rosy runaway that I give a commentary to you here. A doctor, as I said, has to check the patient well before giving the medicines, otherwise the reaction will be bad. So better to check up all your papers from a property lawyer and then decide the course of action. Of course, you have a course of action. I don't want to put cold water on your dreams. You have a full course of action because if your mother has the share in the property, she can definitely claim by going to the court and ask for, she can file a division, ask for family division or family arrangement or insistence on her share of the property by taking the legal course. But please get all your documents properly checked. Ancestral property is more important to see the documentation.
Right. So, Neil, you also need to go to a lawyer and get that ancestral documentation checked and then decide on a future course of action. Your mother, of course, does have rights on that property as well. Uday, before we move on, we are almost at the end of our show. So, very quickly tell us this. We've been speaking a lot about ancestral property today. Now, if I'm holding property and I want to leave my heirs like a clean title, ensure that there is no dispute in future, what are the steps that I need to take as someone who holds property?
There are two ways. Your planning well in advance is very, very important to have no complications because people unnecessarily, I see, create a lot of complications in the property because there is a lack of planning. The planning can be done two ways. During your lifetime, you can make a will and get it registered. That is number one. But then what happens is in various metropolitan cities, this will you have to pay a probate, you have to get it probated, which means minimum 75,000 rupees you have to give plus the other fees. So that many a time people don't have money to get this done also in metropolitan cities, or of course property is worth more but nobody wants to go through. Therefore the other way out is you put joint names in such a way that how you are going to make a will, put the joint names so that or make them co-owners by doing a gift deed. That is still better.
So gifting away the property in your lifetime is the best option.
There is another way. You can even transfer from yourself to your legal heirs and you and your legal heir jointly and divide them in such a way. Suppose you have two sons and one daughter. You are assuming that you have 3 flats. Then what you can do is you can put a joint name of one son on one, second son on another, daughters on another, and do a gift deed in their name or transfer the property. Now, because initially transfer you had to pay the stamp duty. Now, in Maharashtra at least, the government is not charging stamp duty.
Uday, we are running out of time here. So, those are the 3 routes that are really open to you if you hold property, but do ensure that you will the property or gift the property or create that joint ownership structure like Uday said.
And
because
consult
nobody
a lawyer.
likes to leave, nobody likes to leave a mess after, nobody likes to have their heirs fighting over property.
You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/magicbricksnow. And don't forget to click the like button. You can also follow us on Twitter at magicbricksnow. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/magicbricksnow.